The defense in the Senzo Meyiwa murder trial has argued that Magistrate Vivienne Cronje violated constitutional rights of accused No.2 Bongani Ntanzi when she recorded his alleged confession without consent. The state made an application to have the recording admitted as supplementary evidence in the trial within a trial that is looking at whether Ntanzi actually confessed freely and voluntarily. Well, the defense is objecting and says that the audio was obtained illegally. 5 men are currently on trial for the 2014 killing of the football star. Mnisi reports.
In an unprecedented case in South African courts, the North-Gauteng High Court is set to make a ruling on a case of a magistrate recording a suspect without their consent while taking down their confession statement. The novelty of this act has seen the state lock horns with the defense on whether it can be admitted as supplementary evidence in the trial within a trial. Magistrate Cronje made a 3-hour recording of Bongani Ntanzi's confession, and this also included the process of warning him of his right, which is taken down in writing on a document called a proforma. The state's application is to allow the recording to be admitted as evidence.
And what is the state's view about the invasion, the alleged invasion of the privacy of accused No.2, is it? When you make the tape recording, is his constitutional right in terms of Section 14 of the Constitution infringed in that his privacy has been invaded by such taping?
Well, my Lord, would submit that in this instance the recording is the electronic version of what the accused was telling the magistrate. So we submit that there's no room to argue that his privacy was infringed. He was in front of a magistrate making a statement in terms of Section 217, and all that the magistrate did, my Lord, was just to keep a record.
But the defense objects to this, saying his rights to be informed of such a recording ought to have been explained to him.
My submission in relation to the right is that it has been infringed. There's no way that such right, after it has been infringed, it can be cured. Okay. Furthermore, we look at the provisions of Section 35(5). Yes. The legal question here would be, was the recording per se obtained in a rightful way? What does Section 35 say? May I read it, Josh?
I know it.
For record purposes.
Oh, I see.
Yes. It provides that evidence obtained in a manner that violates any right in the Bill of Rights must be excluded if the admission of that evidence would render the trial unfair.
The state indicated that the recording also gives detail of what is already contained in the proforma.
Above meeting the requirements, if they were met, of Section 217, the magistrate who is the witness ought to have explained the constitutional rights of the accused specific to the recording, to say that above what I will be recording, what I will be taking down in the statement, in the document, I will also be recording, and the voice recording will be used in court against you. Yeah. Those constitutional rights, my Lord, I submit that they ought to have been explained to the accused or to the deponent at that time before he made or before the witness proceeded with the recording. My submission, my Lord, is that as we are in a trial within a trial, until such a ruling has been made by this court, the video recording, which was unconstitutionally obtained in terms of Section 35(5), should not be played to the court because it contains incriminating evidence.
Cross-examination had not started when the state made the application to supplement Magistrate Cronje's testimony with the recording, and can only start after this unprecedented judgment has been handed down on Friday morning. For Newzroom Afrika on Channel 405, I'm Mnisi at the High Court in Pretoria.